I think that when employers are searching for an employment law attorney, the number one thing is to find someone who practices in the area regularly. There are many fine attorneys in East Texas. I deal with them quite often in other areas, but employment law, like tax law and other areas of law, is particular. If you're not used to the statutes, regulations, the way the cases go, the flow of the cases or the flow of the investigations or dealing with the investigations, there's many traps for the unwary and the inexperienced in the area. And so I would look for someone who practices in the area regularly. Not just a lawyer, not just an excellent lawyer, but I would say someone who practices locally in the area regularly. It's the old saying, ounce of prevention is better than a pound of cure. So it is important to know an employment attorney before you realize your need for them, or before it becomes painfully apparent that you need them is probably the better way to say it. The idea with hiring an employment lawyer, most of the time, if you're thinking correctly, I would say, is to avoid litigation, is to avoid claims, is to avoid being caught in an investigation when you haven't done everything appropriately. Hiring an employment law attorney would help the business to make sure that they are in compliance with the law as much as they possibly can be. That way, if they are investigated, or if they do have a charge of discrimination filed against them, or if someone does file a lawsuit against them, you can't turn back the clock, right? So the earlier you get on the issue, the earlier you get in compliance with the laws, the safer you'll be. An employer should start reaching out to an employment law attorney, in my opinion, once they start hiring people outside of their family. So lots of businesses start out with either one owner or a husband and wife owner. At that point, you don't necessarily need an employment law attorney, right? You don't have employees. But as soon as you start hiring people, third parties, employees, you need to make sure your pay policies are in compliance with the law, especially when you cross the 15 employee threshold. That is a Rubicon that you need to consider hiring an employment law attorney, because now once you cross the 15 employee threshold, you are then subject to many more laws in the employment law context and regulations. Same thing when you get above the 20, same thing when you get above the 50 employee level. So I would say as soon as you start hiring people outside of the family, as true third-party employees, I would contact an employment law attorney. It won't be super expensive, but you need them then. But if you get to 15 employees as an employer, you certainly need to have a relationship with an employment law attorney, because now you have some serious liability if you're violating those laws. Typically, employers reach out to an employment law attorney when something's going wrong. So it could be a lawsuit, could be a Department of Labor investigation, it could be an EEOC charge of discrimination, or it could be just a termination that's pending that they're worried about doing the right thing. Again, it's better to have a relationship with an employment law attorney prior to those things coming up, but those are the events that most of the time drive an employer to realize, okay, I need someone now. Probably the most common issue that comes up is employee handbooks, just because generally most or all employers have them and they should have them, and it's sort of the step one in getting your house in order when it comes to employment law compliance. However, the Fair Labor Standards Act, that's wage and hour law, right? Salaried, non-salaried, those issues come up all the time, and that applies to basically all employers. And so it's a hot topic in courts, a hot topic in litigation, and so it's become a hot topic when it comes to employers reaching out for legal needs. Now, what's increasing more than I've noticed in the past is actually investigations of employee complaints regarding harassment and discrimination. That is likely because employers are taking those very seriously, given they read the news, and not taking it seriously can have dire effects. And so investigations of complaints is another increasing area. So less common situations where people don't always think about having an attorney that Ramey and Flock can help would be Department of Labor investigations. Again, that's not a lawsuit, but that's something you want to have counsel for. And those come up quite often, and sometimes employers try to handle them themselves, and that can sometimes turn out okay. But it would be very good to have an attorney, and some people don't always think, I need an attorney for this, but my advice would be to have an attorney for those types of investigations. I would also add TWC wage claims at times, so that Texas Workforce Commission wage claims sometimes. It'd be better to have an attorney than not, even though it's not a formal lawsuit, right? Most people know you get sued formally and you need a lawyer, right? That's pretty obvious. But some of the lesser regulatory actions such as DOL, TWC, EEOC, those we absolutely help with all the time and can help protect employers in those situations. I think Ramey and Flock can offer something that most firms can in East Texas, and that is, decades of experience that we have collectively at the firm, and we've been representing East Texas employers and courts here in East Texas for decades. We come from a long line of excellent employment law attorneys at the firm, and we have a wealth of experience combined between the attorneys here, and that's been passed on from one generation to the next. And so we're very familiar with the laws, the courts, the regulations, and you just can't make up for that overnight.